we live in this world where everybody thinks that any mere inconvenience demands redress.
Oh.
And that is simply not the world, okay? If I accidentally step on your foot and I just say, oh, I'm sorry, I don't owe you new shoes. I don't owe you x-rays on your foot. I don't owe you a lunch. Sometimes we are going to be mildly inconvenienced, or even more so than mildly, by other people in this world. But if there is a fix to that makes things right, we've got to get out of our way and get out of where we've been on this trajectory where, we have all these lawsuits and everything, and we're lawyers, where everybody just sues everybody for anything. They thinking, I demand compensation for what has been wrong.
Welcome to episode 122 of the Weekly Docket, a podcast by the Silverman Law Firm where we talk legal news and practical law. Today is May 15th, 2026. I'm Phil Silverman, owner of the firm, and I'm joined by Chris Hield, who's the firm's supervising attorney. Chris, how's life?
Good. Just survived minor surgery in my kitchen, letting my wife take staples out of my head. But that's how I am.
I you and I have that in common. Chris had a slight household accident. We won't go into the details. I also, slipped and fell kind of thing a while ago, and I got the staples in my head. So, I mean, it's interesting that you did what I did. You got a staple gun and you didn't go back to the doctor to have them taken out. All right. The wife took out the staples, right?
Yeah, they said, hey, make an appointment with your GC, which I don't have because I don't go to the doctor. And they said, here's the tool. They may not have it. Don't do it yourself, but here's the tool to do it. So
I'm guessing your wife did a wonderful job removing those staples, and I'm glad you didn't call me because I would have had a vasovagal reaction and fainted. So, all right, we got to keep going here. Let's get this show started. We just have 3 questions we have to answer. These are I haven't even researched them. We're just gonna shoot from the hip on this, and as always, just full disclaimer. We think we're probably right, but no guarantees. All right.
I love that. We need that on every show.
Right. All right. So look, first question. All right. Somebody is currently doing a probate, all right, over her father's will. Okay. The stepmom, father died, remarried, stepmom is alleging that our client is not the adopted daughter. And the probate court is saying that they're not going to unseal the files regarding the original adoption paperwork. Does that sound right? I mean, I'm just thinking, and how do we potentially solve this problem? My gut instinct is, do you really need to go back and find all the adoption paperwork? Isn't it just sort of a fact issue where the attorney ad litem is maybe going to sort that out? Or what do you think?
I don't think there's a consensus on what ad litems do. I have strong opinions, and I think some judges would disagree with me. The ad litem's not necessarily the determiner. They're just sort of the court's investigator, even though there are court investigators. So it's not really up to the ad litem to make a determination, although their findings are often instructive. Some ad litems will do a report that says, I have located the following heirs, and there is an issue as to this person. Should this person prove to be adopted, they will be an heir. Should this person not prove adoption, they would not be an heir. So they kind of skirt the issue because, I mean, in reality, the ad litem's function should really be to identify unknown heirs. That really should be the ad litem's function. Anyway, I'm a little confused, though, because if you are the subject of the adoption, I'm not a family lawyer, but I would think you would have the ability to get the records for your own adoption.
I would agree with that. And this is a question that came out of our legal, chat room where the attorneys kind of just rely on each other to answer some of these questions. Yeah, I would think even as an adult, you've got the ability to go back and get the adoption paperwork. And then that can be presented as evidence during the determination of heirship proceeding, correct? And you'd agree with that?
Yeah. There should be, I mean, if nothing else, there should be an order.
Yeah.
There should be an adoption decree or a final judgment on the adoption case. Just like, people don't think about them necessarily as lawsuits, but a probate's a lawsuit, a divorce is a lawsuit, and an adoption is technically a lawsuit because it adjudicates certain legal rights. So I would think you would at least be able to get the judgment.
Yeah. And the judgment can obviously be used in court to establish the adoption. Assuming you can't get it, as this happened years ago, they don't have it, whatever. I don't know. It'd be shocking if you couldn't find it. Then I think you are going to come down to a factual analysis on whether this adoption actually occurred. Maybe you get into adoption by estoppel. I don't know at that point. So, real quick,
I think you'd have a pretty good case. Because adoption by estoppel really does step in if there's a failed adoption. So if you intended to adopt and, you didn't get the paperwork right, or it didn't go through for one reason or another, but then you proceeded on as though the adoption went forward, I think that really presents a strong case for that.
And my recollection is that the courts have even softened on the rigorous requirements of adoption by estoppel. They've made it a bit less onerous to establish adoption by estoppel. So probably a pretty decent shot for this potential new client or client, whoever this is, to prove that they were in fact adopted and attempt to defeat evil stepmother's contest on the heirship. So, okay, moving right along on that. Here's our next legal question for the day, and we're only going to do two more, so a very short show again. I received a security deposit dispute from a past tenant. I think this one came from somebody at the management company, maybe. His complaint is that the lease terminated on March 31st of 2026, and the envelope containing the deposit, accounting, and refund check was postmarked May 5th, 2026, well beyond the statutory 30-day deadline required by Texas law. Does this really matter? Question mark.
I remember seeing this, and I, you may have biased me, but I think I agree with you. The only part of the statute I'm not 100% clear on. So like you said, as a landlord, you have 30 days to forward the tenant's deposit. And then if you don't do it within 30 days, and I don't remember if it's 30 days from move out or 30 days from when you receive the forwarding address, but you've got the 30 days. If you don't give it within 30 days, it's presumed to be in bad faith.
Right.
And you have to get that bad faith finding in order to get the treble damages.
That's right.
So if they did do it a week later, that seems very difficult to find bad faith. It feels like they, even if they were intentionally dragging their feet, it's a week.
Yeah.
So how much are they really going to hold them to? And then it's, treble damages on the amount wrongfully withheld. Typically when we get the case, it's my landlord withheld my $2,000 deposit and I don't have a check for $2,000. So we're claiming the amount wrongfully withheld is $2,000. Well, if it's a $500 deposit and you did get the $500 eventually, does the $500 still count as the amount wrongfully withheld? Or is it now $0 wrongfully withheld? That I don't know.
Yeah. I'm sort of an expert in this one area, not proudly, because it's not a very profitable area to practice, just because, again, I own a management company. I think 99% of what you said is just correct. The only thing I would clarify is it's when a tenant moves out, they have to provide a forwarding address. The surrender of the possession and the forwarding of the address to the landlord and management company, that's what triggers the 30 days. So
Okay.
if you assume the facts is true, which they were not in this case, it turns out that the tenant actually sent the forwarding address in very late April. So the May 5th was plenty timely, but let's just assume the facts is true because it makes a more interesting legal question. If the management company or the landlord really, in fact, was 5 days late, what attorneys and tenants always get wrong is they think they've won the lottery. Like, yay, they're 5 days late. Now I automatically get 3 times damages. And that's just not true. It's an analysis of bad faith, and missing it by 5 days probably is not bad faith. I have read some cases where the courts will weigh, was it a mom and pop landlord that just didn't know, because that's clearly, or was it a professional landlord? If it's a professional landlord that waited like 2 or 3 months, that could be considered bad faith because they're held to it to a higher standard. So that's how you get into to that analysis. So hopefully that provides some clarity to both landlords and tenants out there. If tenants are listening,
Do they do the calculation based on the refund amount? So if they wrongfully withheld your $2,000 deposit for a month, but then did give it back, are you still entitled to this
that I can't remember. So I just said I was an expert, but then apparently not from memory. I'm not, because I just cannot remember that portion of it. So I don't.
Because a lot of what we have, and like you said, this isn't one we do tons of, but we have tried cases like this. This does come up. It's, the landlord will then kind of, as all tenants will tell you, make up charges and say, oh, well, how convenient that my deposit was $2,500 and then you found $2,500 in damages and repairs. And so then we're alleging that the amount wrongfully withheld is the $2,500 because the tenant didn't get any money back because the landlord said, oh, there were scratches on the floor, the sink wasn't working, the grass wasn't cut, so I had to reseed the whole yard and I had to get professional landscapers in.
Yeah. That you do see a lot of that, and there are a lot of unscrupulous landlords out there that just make up numbers. I don't advise this, but it's kind of like, if you're gonna be a liar, maybe do you want to aspire to be a good liar? So if you're a landlord out there pencil whipping the damages amount, are you gonna really hit it right on the head, like $2,500? That's all my charges. You want to be like, mas o menos, like a little up or down to make it look legitimate. I remember we don't practice tax, but we do have clients that are in tax trouble, and we refer them out to lawyers that do tax defense with the IRS. And I'll never forget, I was sitting with the CPA one time, and he was looking at somebody's, a client's return or something like that. And I just happened I was working with him on something else. And the CPA looks at it and is like, every single amount on that return ended in like a round number. Like the expenses for advertising were $35,100, right? Or the expenses for office supplies were 15,000 even. And that's just an immediate red flag with the IRS. You mentioned it one time. I don't think you remember making the statement, but you mentioned it one time with guardians in the concept of the guardianship proceeding. If a guardian is really being unscrupulous and taking advantage of the ward, the guardian's expenses will come back with round numbers too, right? So
that made sense. Yeah, because a lot of times they don't track it, and the courts will definitely catch that. They want receipts. They're not going to say, oh, you spent about this much on the ward. Sounds good to us. They will definitely not accept that.
They're going to disallow it. Just like the IRS will take issue with it. Sounds like the courts will take issue with it. Okay. Last legal question for the day. I get this one all the time, and they get mad at me when I give them the answer. It's such a silly thing. I shouldn't say that, but okay. So I sold a property. You're the seller. And the title company accidentally paid me too much money. Do I have to give the money back? Question mark.
Yes,
that was an easy one. There's something, I've tried all different kinds of ways to explain this to people, and it's like, it's the old story. If you go to the store and you buy, back then we used cash. I don't know who still uses cash at the store, but If you gave someone $20 and you got too much change back, you don't get to keep the change because the clerk made the mistake. It's the same thing in title companies. Just because the title company made the mistake, you don't get to, as the seller, say, "Ha ha, it's too late. Your mistake. I'm keeping the money." Right? It's just common sense. And if you don't pay it back, then the title company is going to have a right to sue you. In fact, you're signing documents that I think include language in there. In contracts, we call them further assurances clauses. It's sort of related, but if we mess everything up and there was an omission, you agree to come back and sign stuff and make it right. A little bit different, but related concept. So,
Well, you're right. And I get worse reactions than you because I'm not as nice as you, even though what I think you just said would get mean reactions because you're you and you deliver it better. But what I say, and I'll take all the hate comments, let's just, whatever interaction we get is whatever interaction we get. But this is really what I tell people. I say, look, we live in this world where everybody thinks that any mere inconvenience demands redress.
Yeah.
And that is simply not the world. Okay. If I accidentally step on your foot and I just say, "Oh, I'm sorry," I don't owe you new shoes. I don't owe you x-rays on your foot. I don't owe you a lunch. Sometimes we are going to be mildly inconvenienced, or even more so than mildly, by other people in this world. But if there is a fix to that makes things right, we've got to get out of our way and get out of where we've been on this trajectory where, we have all these lawsuits and everything, and we're lawyers, where everybody just sues everybody for anything. They thinking, I demand compensation for what has been wrong. Not everything goes that way. And yes, the title company made a mistake. And yes, I understand you went and spent the money and you're saying, "I don't have the money now." You got something you should have never gotten. They're only taking back what you shouldn't have gotten. Yes, I get it's annoying. You don't appreciate this. You can be pissed off, but you're not entitled to compensation and you're not entitled to keep the money. And I get it. You can be annoyed, but that's it. We don't get compensated for our annoyance.
That's well said. We need to end the show on that quote. Every mere inconvenience does not require redress. That almost sounds like that came from a case opinion somewhere, but in like one of the early 1900 case opinions, it's just well said. We got to end the show on that. So just people out there, remember, if you're listening to the show, okay, you get bumped, somebody nicks your car door or whatever, it doesn't always rise to the level of a lawsuit, right? That brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcast. Remember, as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your Friday and weekend.